This podcast covers property law. Let's begin with the plain meaning of property. Property can be either real property or personal property. What qualifies as real property? Real property consists of land, structures that are built upon or attached to the land, growing timber and crops, airspace above the land, minerals underneath the surface of the land, such as gold or oil. What about items which don't neatly fit into one of these categories? Let's say, for example, window blinds. The determination is based upon the character of the property, how the item is affixed to the building, the intent of the parties relationship. For example, are the parties lessor and lessee, or are they mortgagor and mortgagee? What about a mobile home? It is most likely personal property, but if it is affixed to the land, then it becomes real. What about growing trees? They are treated as real property, but if they are cut down, then they change and become personal property. How is a person's residence treated? As real property. Who has rights to this property? The owner has rights. She has a deed. The mortgagor or lender, any contractor or other worker who may have a lien on the property. Thus, if the bill is not paid, that person has a right to part of the property. Any lessee who has a leasehold interest in the property. What about personal property? Personal property can be tangible or movable, and it can also be intangible. Examples of tangible property include a car, furniture, golf clubs, and clothing. Examples of intangible property include stock, promissory notes, bonds, patents, copyrights, and trademarks. Patents, copyrights, and trademarks are intangible property rights called intellectual property. A patent is a government grant for the exclusive right to make and sell an invention. For example, a time machine. A patent generally lasts 20 years. A copyright is an exclusive right granted to an author of books, music, or other creative work. One example of a copyright infringement you may be familiar with involves the song Blurred Lines by Robin Thicke in 2013. In that case, a jury found that Thicke committed copyright infringement regarding Marvin Gaye's 1977 song Got to Give It Up and awarded $7.3 million to Gaye's family. Some famous patents include: in 1836, Samuel Colt patented the revolver. 1840, Samuel Morse, the Morse Code. 1930, Clarence Birdseye frozen food, so on and so forth. A trademark. It's a word or a symbol used to identify a product, such as a Nike Swish, McDonald's M, or an apple. The law provides specific rules for how to determine ownership of personal property. First, does a person have dominion and control over the property? Second, does the person have possession of it? Possession can be actual, I actually hold a gold watch, or constructive. I have the only key to the safe deposit box which contains the watch. What about if a gift is made? In the case of a gift, courts examine the donor's intent and whether or not delivery has been made by the donor and accepted by the donee. Third, certificate of title is examined. For example, does one have certificate of title to a car? This would establish ownership. Lost, mislaid, and abandoned property. What happens to property that is lost, mislaid, or abandoned? Who owns it? Lost property. This is property where the owner accidentally and involuntarily parted with possession and doesn't know where to find it. The key factor here is where the item is found. A watch on the floor of a public place. Here, a reasonable person would not leave her watch on the floor of a public place. So it is considered lost. The rule is that the finder of the lost property has a right to it against everyone except the true owner. An example is you accidentally leave your gold watch in class and I'm the lucky one who finds it. I have a right to it against everyone except you, the true owner. Now, an exception might be Phoenix College might claim it has a legal right to the watch and may hold it for the true owner. Mislaid property. Here, the owner intentionally placed an item somewhere and the item is later forgotten about. Again, the key factor is where the item is found. An example is a briefcase found on a desk. In this case, the true owner has a right to it, or if not found, the owner of the location where the property is found gets to keep the item. In 2012, the Arizona Court of Appeals determined that cash found in the kitchen walls of a homeowner during a remodeling project was mislaid property, and it belonged to the original owner, who was deceased, so it went to the original owner's estate. Neither the new homeowners nor the contractor who found the cash while remodeling the home had the right to keep it. The court went back to the definition of mislaid property to make the determination. Abandoned property. This is property where the owner voluntarily relinquished all ownership. The finder has a right to it against everyone else. For example, refrigerators left in the building the owner knew was going to be destroyed is considered abandoned property. ARS Section 13-1802 defines theft. A person commits theft if the person knowingly comes into control of lost, mislaid, or misdelivered property of another under circumstances providing means of inquiry as to the true owner, and appropriates such property to the person's own or another's use without reasonable efforts to notify the true owner. Can a thief transfer title? Let's say you buy a Monet from what you think is the legitimate owner. It turns out it was stolen. The true owner has a right to its art. The thief never had title to the art, so it could not transfer or sell it. Bailments. A bailment occurs where someone receives possession or custody of personal property without ever acquiring ownership. For example, let's say you watch a classmate's purse while she goes to the bathroom. One party, the bailor, temporarily delivers personal property to another party, the bailee, and the bailee accepts the property. With a gratuitous bailment, there is no compensation. For example, you go to the bathroom and ask a classmate to watch your purse. You are the bailor, and your neighbor is the bailee. No money is exchanged. Why do we care? The standard of care. If you borrow your neighbor's lawnmower, here the benefit is to the bailee. You are the bailee, and you must return the lawnmower in good condition. But if you ask your classmate to watch your purse, there the benefit is to the bailor. Your classmate's standard of care is minimal. Thus, if the purse is stolen, the classmate is probably not liable. Mutual benefit bailments. These occur where one party receives a benefit and the other party receives compensation or money. For example, you bring your car in for service, or you store goods in a facility. You are the bailor. The bailee must use reasonable care with respect to your goods. What about a leased premises? There, the lessor or owner is the bailor. The lessee or renter is the bailee. The duty is reasonable care. What about a leased car? Same. The duty of care is reasonable care. Parking a car? The bailor is the owner of the car. The bailee is the garage. The car owner receives a temporary parking space and the lot owner receives money. It is a mutual benefit bailment. What happens if a phone is stolen from the car? Is the garage liable? Well, we have to ask if the duty of reasonable care was breached. Does the lot owner have a sign stating he is not responsible for lost or stolen property? Also, how do you prove that the phone was in the car? How is real property legally transferred? By warranty deed. This is a document that contains covenants to protect the buyer. The seller covenants to the buyer that the seller holds title to the property and is able to convey to the buyer. To be effective, the deed must be signed and delivered to the buyer. A deed recorded in public records is presumed to have been delivered and accepted. Mortgages. Let's say you buy a house and need to borrow money for the purchase. You might pay cash if you are very lucky and solvent, but more commonly, you might take out a mortgage, an agreement with a bank where the bank agrees to give you money and you agree to pay the bank back over time with interest. In this case, you sign a promissory note Also, as collateral for the loan, the bank takes a lien against the property. The borrower is the mortgagor and the lender is the mortgagee. The homeowner, or the mortgagor, makes monthly payments of principal and interest on the loan. The covenants in a mortgage include a promise to promptly make all payments of principal and interest, pay real estate taxes and assessments, keep improvements on the property insured against casualty, loss, and fire. What happens if the mortgagor sells the home? In that case, the lender's interest remains intact. The buyer buys the home subject to the lien on the property. What happens if the mortgagor fails to pay the amount owed to the mortgagee or the lender? In that case, the mortgagee or the lender can foreclose on the property. The property is then sold at public sale and the proceeds go to the lender. If the lender is still owed money, then the court will enter a deficiency judgment against the mortgagor for the balance due. And this happens in all states except in a non-recourse loan state, which Arizona is. Arizona is a non-recourse loan state. So in Arizona, the lender cannot seek a deficiency judgment. Some states use a deed of trust instead of a mortgage. In that case, the borrower deeds the property to a trustee or a straw man, and the trustee holds title to the property. If the borrower defaults, the trustee sells the property at public auction. Recent history has shown us how unpredictable the financial markets are, and we have also learned lessons regarding lending practices. Let's start with the mortgage meltdown of 2008 and the Great Recession. Housing prices rose in the 1990s and 2000s. Lending standards declined greatly. It was quite easy to get a loan, and there was almost no requirement that the borrower show his or her ability to pay. In 2006, this housing bubble burst as housing prices went into steep decline, the economy tanked, and the homeowners couldn't pay back their loans. As the housing prices dropped, many borrowers found that their homes were worth less than the money they owed on the loan. They were considered underwater. So these borrowers stopped paying their loans. There was a high rate of default. These borrowers were able to keep their homes, however, even though they stopped paying their loans. And how was this possible? The loans they had taken out had been sold as bundles to other lending institutions. When the homes went into default, the lenders went to foreclose, and the borrowers claimed fraud and misrepresentation with regard to the fact that the loans were sold without their permission. This led to a huge financial meltdown as the lenders lost billions of dollars and government bailouts. Finally, this led to higher standards in lending. 12 years later, in 2020, America entered into another financial crisis due to the coronavirus pandemic. This time, banks were better equipped to handle the crisis, and the federal government initially acted quickly to provide bailouts. However, the crisis lasted longer than most predicted, and the funds from the bailouts quickly ran out. The Great Recession lasted from 2007 to 2009. It took nearly 18 months for the major stock indexes to fall by 50%. That long decline shook investors out of the stock market. Those who stood on the sidelines missed the 10-year rally that followed. The 2020 market crash, in contrast, happened so quickly that investors were largely in a state of shock. The S&P 500 index fell by 34% between February 19 and March 23rd, the fastest fall in a bear market in history. Estates and real property. This refers to how title to real estate is held. These titles are derived from English common law. Title to property can be held as individual title. Title to real estate can be held in joint tenancy. Same-sex couples prior to the Obergefell case, legalizing marriage for same-sex couples, frequently held titles as joint tenants. This is a special form of ownership by two or more persons of the same property. The individuals who are called joint tenants share equal ownership of the property and have the equal undivided right to keep or dispose of the property. Joint tenancy creates a right of survivorship. This right provides that if any one of the joint tenant dies, the remainder of the property is transferred to the survivors. If the joint tenants mutually agree to sell the property, they must equally divide the proceeds of the sale. Because disagreement over the disposition of the property is common, courts sometimes intervene to divide the property equally among the owners. If one joint tenant decides to convey his or her interest in the property to a new owner, the joint tenancy is broken and the new owner has what's called a tenancy in common. A tenancy in common is a common title with business partners. Here, each owner has an undivided interest in property. It's a form of concurrent ownership that can be created by deed, will, or operation of law. Several features distinguish it from a joint tenancy. A tenant in common may have a larger share of property than the other tenants. The tenant is also free to dispose of his or her share without the restrictive conditions placed on a joint tenancy. So she may gift, sell, or devise her share. Unlike a joint tenancy, tenancy in common has no right of survivorship. Thus, no other tenant in common is entitled to receive a share of the property upon a tenant in common's death. Instead, the property goes to the deceased's heirs. A form of tenancy that is available to only a husband and a wife, or now also same-sex couples. It can be created by will or by deed. These are tenancy by the entirety. As a form of joint tenancy that also creates a right of survivorship, it allows the property to pass automatically to the surviving spouse when a spouse dies. In addition, tenancy by the entirety protects a spouse's interest in the property from other spouse's creditors. Same-sex couples can now legally marry, thanks to the U.S. Supreme Court in Obergefell, and therefore have a tenancy by the entirety. This means their interest is protected from creditors. One exception is the IRS. So, should a spouse get in a car accident and there is a judgment against the spouse who dies, the judgment cannot reach the property held in a tenancy by the entirety. It differs from a joint tenancy in one major respect. Neither party can voluntarily dispose of his or her interest in the property. In the event of divorce, the tenancy by the entirety becomes a tenancy in common, and the right of survivorship is lost. Community property laws provide that each spouse owns a half of the property acquired during marriage. This rule does not affect two types of property. Number one, ownership of property acquired by either spouse prior to their marriage, or number two, property acquired by gift or inheritance. Those types of property remain separate. Interest in another's land can refer to life estate, a leasehold interest, a license, easements, eminent domain, and adverse possession. A life estate, for example, you own your home, occurs where you are a life tenant. You enjoy interest in your land for life. A leasehold, for example, you lease an apartment, occurs where you have a possessory interest in a specific period. The parties here include landlord and tenant, or lessor and lessee. Many states have statutes or laws that control the relationship between a landlord and a tenant. Arizona has the Arizona Residential Landlord and Tenant Act. A license is a temporary grant of authority to access someone's land or property for a specific purpose. For example, to hunt or fish, remove firewood, or take photos. Easements are defined as an easement is the grant of a non-possessory property interest that grants the easement holder permission to use another person's land for a specific purpose. The easement holder does not have the right to possess and enjoy the property. He can only use it for the specific purpose. Usually, the purpose involves a right to travel across another person's land for ingress and egress, or entry and exit. Common examples include laying utility lines, installing sewer pipes, hikers cutting across someone's backyard to access a mountain. Easements can also be by necessity or prescription. By necessity occurs when an owner needs an easement in order to access his property. His parcel is literally landlocked. He has no access to a public road except by another person's land for ingress and egress, which means entry and exit. By prescription occurs where an owner makes a continuous and uninterrupted use of property. This type of easement is for convenience. A common example is a pedestrian who uses a sidewalk. Many of you may be familiar with the concept of eminent domain from the Constitution or the news or both. Per the Fifth Amendment to the U.S. Constitution, the government has the power to take real property from private citizens or private businesses. The property must be for public use. The government must provide just compensation or the fair market value of the property. Eminent domain has been used to condemn land to build infrastructure such as roads, bridges, canals, power plants, and railroads, amenities such as parks and schools. It has been used for economic development such as to build stadiums and waterfront development. Just compensation is usually determined by real estate appraisers and is the fair market value of the land. Adverse possession occurs where one occupies another person's land with the intention of possessing it as his own. A common example of adverse possession occurs where one property encroaches on a neighbor's land. The person in possession of the land may acquire valid title to it, so long as certain requirements are met. These include the land is held for the statutory time period, which is somewhere between 7 to 20 years. In Arizona, the statute requires a 10-year period. The possession must be open and notorious. This means the possession is not in secret or it is open for all to see. The possession must be actual and exclusive. The possession is continuous and it is hostile, meaning there is no consent from the owner. Wills. These are legal instruments in which people dispose of their property at death. Testamentary capacity requires, in order for the will to be considered valid, the testator be of sound mind and she understand her actions. In the case of no will, her property passes by intestate succession. In this case, who gets the property? We look at both separate property and the community property. The intestate share of a surviving spouse with no children results in the surviving spouse acquiring the entire estate. She acquires all the community property and all the separate property. If there are children, their surviving spouse receives 1/2 of the community property and 1/2 of the separate property. The children receive 1/2 of the community property as well, and 1/2 of the separate property as well. This concludes our podcast on property law.